Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. And also guys, if you are in foreclosure and need help with your foreclosure, you can always email me at this email address, the number 4, foreclosurehelp777@gmail.com. And thank you for subscribing. If you haven't subscribed, please subscribe so you don't want to miss any upcoming videos. Today we're going to talk about HOA foreclosures and what homeowners need to know. And we'll start with the verse of the day, the Bible verse of the day, which is Romans 13:8. Owe no one anything except love each other. The borrower is servant to the lender. Proverbs 22:7. Ownership involves wise financial management to avoid becoming a slave to lenders. So you want to look at responsibility, awareness, wise management, and understanding your obligations. Okay, so what is an HOA? An HOA is a homeowners association, declarations of covenants, CC and Rs, bylaws, assessments, and how HOA obligations run with the land. Many people do not realize that buying into the community usually means agreeing to the recorded covenants. How HOA liens arise? Well, they'll put a lien on your property for unpaid assessments, late fees, attorney's fees, interest, fines, special assessments. In many states, unpaid HOA assessments automatically become liens against the property under the state statute or governing declaration. Now let's look at the difference, judicial versus non-judicial HOA foreclosures. This is fascinating because states differ dramatically, guys. Some states require judicial foreclosure, while others allow non-judicial procedures. You can compare states again like I did with the mortgage standing. Super priority liens. This is one of the most important concepts. In some jurisdictions, part of the HOA lien may take priority over even the first mortgage. So you could be paying your mortgage and still lose your house to an HOA. Due process and notice issues. Okay, notice requirements, opportunity to cure, payment disputes, hearing rights, improper fines, selective enforcement. Let's explain this. Even where HOAs possess statutory lien rights, they generally must comply with procedural requirements before foreclosing. There is abuse and controversy, aggressive fee escalation, attorney fee stacking, foreclosure over relatively small debts, management company conflicts, questionable fines, lack of transparency. Now, your defenses and challenges, potential issues include improper notice, accounting disputes, invalid fines, statute violations, selective enforcement, failure to follow governing documents, expired liens, payment application disputes. So, if you look here at this chart here, mortgage versus HOA foreclosure, you'll see on the left the mortgage foreclosure is based on the promissory note, whereas the HOA foreclosure is based on covenants and assessments. The mortgage foreclosure usually has a large debt. The HOA foreclosure sometimes relatively small debt. The mortgage foreclosure is governed heavily by the Uniform Commercial Code and mortgage law, whereas the HOA foreclosure is governed heavily by HOA statutes and declarations. The mortgage foreclosure involves the lender or servicer, and the HOA foreclosure involves association and a management company. The mortgage foreclosure means standing often centers on note ownership, whereas the HOA foreclosure authority often centers on governing documents and statutory compliance. Many homeowners carefully review their mortgage documents but never read their HOA declaration. Yet HOA powers can include liens, fines, collection actions, and even foreclosure authority under the state law. So understanding those rights and limitations matters. Now let's talk about stopping or challenging an HOA foreclosure. The available remedies depend heavily on whether the state uses judicial or non-judicial foreclosure procedures. In a non-judicial HOA foreclosure state, the homeowner often must file suit because the foreclosure may proceed outside court supervision. The homeowner may need to initiate litigation, seek injunctive relief, or request a temporary restraining order. Potential claims or issues may include improper notice, accounting disputes, invalid fines, failure to follow HOA governing documents, statutory violations, payment disputes, selective enforcement, expired liens, or lack of authority. In non-judicial states, waiting too long can be dangerous because the foreclosure process may continue unless a court intervenes. Okay, common strategies in non-judicial states. Like I said, 1, injunction or TRO. The homeowner asks the court to temporarily stop the sale while disputes are litigated. Courts often examine the likelihood of success, irreparable harm, notice defects, and statutory compliance. Number 2, demand accounting records. Disputes often exist over fees, attorney's charges, fines, interest, and payment application. Sometimes balances escalate dramatically. Challenge HOA compliance. Did the HOA follow its declaration, follow bylaws, comply with state statutes, provide required notices, properly authorize the foreclosure? This is critical. Number 4, payment plan settlement negotiation. Many HOA disputes resolve through payment plans, mediation, negotiated reinstatement, or fee reduction. In judicial HOA foreclosure states, the HOA must file a lawsuit. This means the homeowner can respond directly in court. You can assert defenses, you can conduct discovery, and you can challenge the HOA's evidence. Potential defenses in a judicial state include improper notice, disputed accounting, invalid fines, statute limitations, failure to follow governing documents, selective enforcement, waiver, estoppel, or procedure violations. Common judicial state strategies is file a timely answer. Ignoring the lawsuit may result in a default judgment. Number 2, demand proof. Require the HOA to prove the debt, the governing authority, the notice compliance, the fee calculations, and foreclosure authority. Number 3, discovery. Homeowners may request ledgers, board minutes, notices, management agreements, and records supporting the charges. This can expose errors or inconsistencies. Raise procedural defenses. Courts often care deeply about statutory compliance, notice timing, voting requirements, and due process protections. Okay, let's talk about bankruptcy and HOA foreclosures. A bankruptcy filing may trigger the automatic stay under federal law and temporarily halt collection and foreclosure activity, but homeowners' assessments may continue post-petition in some circumstances, and bankruptcy is a serious decision requiring careful consideration. Let's talk about Nevada, the super priority lien state. And here's a case called SFR Investments Pool 1 LLC versus U.S. Bank N.A. This landmarks Nevada Supreme Court case held that HOA super priority liens may be foreclosed non-judicially under Nevada law. Such sales could extinguish first deeds of trust. That shocked the mortgage industry. The case demonstrated how powerful HOA lien statutes can become when combined with non-judicial foreclosure authority. Due process concerns. Here's a case, Bourne Valley Court Trust versus Wells Fargo Bank N.A. This case focused on due process, notice requirements, and constitutional protections. The court examined whether Nevada's HOA foreclosure framework provided adequate notice before extinguishing property interests. Even in non-judicial foreclosure systems, constitutional due process concerns may still arise when property rights are affected. What is a super priority lien anyways? Some jurisdictions, part of the HOA lien grants priority over even a first mortgage. That means failure to satisfy HOA assessments may jeopardize the lender's lien position. And in this case, City Mortgage Inc. versus Court Madura Homeowners Association. 9th, 2020. This case detailed Nevada's statutory framework allowing HOAs to purchase super priority liens and foreclose non-judicially. The court explained that Nevada's revised statutes permits HOAs to foreclose on 9 months of assessments plus nuisance abatement charges through non-judicial sale, which takes priority over the first mortgage. Judicial HOA foreclosure states. Here's a case called C&C Investments LP versus Martha Hummel. In judicial foreclosure systems, courts are more directly involved and due process protections become even more explicit. In this case, the court stressed that notice efforts must be made in good faith and reasonably calculated to actually inform the homeowner. This is important. This is an important fairness principle. Then there's hybrid states with unique rules. Holly Park Condominium Homeowners Association versus Lowry. This shows something very important. Governing documents themselves may affect foreclosure authority. This is a sophisticated but practical point, even where statutes permit non-judicial foreclosure. Declarations, condominium documents, and bylaws may impose additional limitations. California's redemption twist. Here's a case, Multani versus Winkin and Neal. Most non-judicial foreclosures do not include redemption rights afterwards, but California HOA foreclosure law provides additional homeowner protections. That demonstrates again, every state is different. So some key legal distinctions here. Judicial versus non-judicial. Court oversight. In judicial, significant court supervision. Non-judicial, no court oversight. Notice requirements in judicial states. Due process requires actual notice efforts. Non-judicial, notice must be reasonably calculated to apprise interested parties. Redemption rights in judicial states, statutory right of redemption generally is available. In non-judicial states, no post-sale redemption except California HOAs. Deficiency judgment are available in judicial states. Non-judicial foreclosure states generally not available. Super priority liens may require judicial enforcement, and in non-judicial states can be foreclosed on non-judicially in Nevada. And here's an example of homeowners successfully challenging an HOA foreclosure. Windrose Homeowners Association versus Hale. In this case, the homeowners successfully challenged an HOA foreclosure sale after the association obtained the property through an extremely low foreclosure bid. The South Carolina Supreme Court set aside the foreclosure sale after concluding that the bid price was so grossly inadequate as to shock the conscience of the court. The HOA winning bid represented only approximately 4.9% of the property's value. The court emphasized long-standing equitable principles, recognizing that foreclosure sales may be invalidated where the price is unconscionably low, the circumstances are inequitable, or the sale process produces fundamentally unfair results. Example, strategic payment defeating HOA super priority lien extinguishment. It's Wilmington Trust National Association versus Satakoy Bay LLC. In this case, the court ruled that HOA foreclosure sale did not extinguish the senior lien deed of trust because the homeowner had already paid the super priority portion of the HOA lien before the foreclosure sale occurred. The HOA accepted and applied the payments toward the super priority assessments. As a result, the court concluded that the super priority default had been cured, the foreclosure sale could not extinguish the first deed of trust, and the purchaser could not obtain full title free and clear of the senior lien. The court explained that once the super priority position was satisfied, the HOA could no longer foreclose that portion of the lien to wipe out the deed of trust. In some jurisdictions, understanding the structure of the HOA liens and acting early may dramatically affect the outcome of the foreclosure dispute. So based on these based on these cases, homeowners have successfully challenged HOA foreclosures on the following basis. You can see here, challenge is grossly inadequate bid price. The case was Windrose HOA versus Hale. The sale was set aside. And in this one, statutory redemption rights, the Satacoy Bay versus Nevada Association, the homeowner retained title. Payment prior to sale, Wilmington Trust versus Satacoy Bay, sale declared void. Lien not actually in default, Satacoy Bay again versus Bank of America. The sale was voided. Okay guys, I hope this information has been informative. If you have an HOA, you might want to be real careful about not going into default with them or doing anything that might jeopardize your case, and certainly helpful to people that are fighting foreclosure that have an HOA involved. If you have any questions or comments, you can leave them below or send me an email. And I hope everyone has a blessed day.